Hello, everyone, and welcome to the WGA webinar, Land Management Conflict, Current Litigation and the Future of Alternative Dispute Resolution. This webinar is the fourth in a series for Montana Governor Steve Bullock's National Forest and Rangeland Management Chair Initiative. And before we begin, I just want to familiarize you with some features of WebEx, which we'll be using. Please notice the Q&A function on the upper right-hand corner of WebEx. You can use that function to submit questions to the panelists throughout the webinar, and we'll be collecting those and referring them to the panelists. The webinar runs from 9 minutes, or for 90 minutes, and you can submit questions at any time, and we will get to those. So thank you for joining. I will now hand it off to Troy Timmons, the lead, WGA staff and lead on this initiative.
Thank you, Bill. As Bill mentioned, this is the latest in a series of webinars supporting the WGA initiative of Governor Steve Bullock of Montana that's focusing on national forest and rangeland management. The initiative in general, I'll just take a second to talk about that, has been examining a broad range of land management challenges. First, it's been providing an opportunity for Western states to exchange ideas on what is working and what is not working in their efforts to responsibly manage the lands in their states. We've also been looking at the role that collaboratives and collaborative processes play in helping federal land managers prioritize their work and evaluating how we can improve those collaborative processes. We've also been looking at existing statutory authorities like good neighbor, stewardship contracting, and others that allow states and local communities to leverage their influence in how those land management decisions are made and examining ways to enhance those tools. Throughout the course of the initiative, one of the things that's been clear is that one of the persistent concerns of that land management decision-making process is the potential for litigation over those decisions. It's not limited to one part of the resource management spectrum. In one case, you may have conservation groups that are unhappy and will seek to use the courts to halt a decision. And in the very next case, it may be industry groups that are unhappy and use the courts for redress. Access to courts is an important protection afforded to American citizens, and one of the things we want to emphasize is that access to our legal system should be safeguarded. I don't think anyone would disagree with that. But it's also important that federal and state agencies and private landowners have the ability to implement land management decisions that have a strong base of support in a timely manner and not allow judicial processes to unreasonably impede the implementation of projects. So today's webinar will begin to look at that issue. I don't think we're going to answer every question that's out there, but we will start to get at the roots of this thorny issue. And I guess from our standpoint, one of the questions we want to ask is, are there decision-making processes that lend themselves to more litigation than others? And are there methods that federal and state land managers can use to mitigate the risk of litigation? What do those look like? I'm hopeful this morning's discussion can help shed some light on that topic. I want to thank David Dreher for moderating this panel and taking on what is an incredibly difficult subject. We've got a great panel put together for this discussion, and I really look forward to our time today. With that, I'll turn it to David, and I'll let you get started.
Thank you, Troy, and I want to thank both Bill and Troy for putting this together and getting us all on the phone today. And I think that Troy did an excellent job of setting the stage for the conversation that we're going to have today and providing a little bit of context for the discussion. First, I want to introduce our panelists. We've got 4 of them today. Susan Jane Brown, who is the Wildlands Program Director and Staff Attorney at the Western Environmental Law Center in Portland, and she's also a key figure in the Blue Mountains Forest Collaborative in Eastern Oregon. We have Laura Ziemer, who is Senior Counsel and Water Policy Advisor at Trout Unlimited in Bozeman. Chris French is the Director of Ecosystem Management Coordination here in Washington, D.C. at the U.S. Forest Service. And finally, we have Jim Riley, who is the principal at Riley and Associates. And Jim represents a number of clients, both in natural resources and transportation and some other things at the state and federal level. So I want to thank all of them for being here. I know that they all have busy schedules, and we appreciate the time that all of them have taken to be with all of us. So with that, I think that I'll further set the stage a little bit for the conversation that we're going to have and offer the premise or the lens through which I have started to think about this topic. And it's that 30 years ago, the natural resources disputes that we had were fundamental questions of law, many of them. For example, was the agency fulfilling its viability requirements under NEPA? The answer turned out to be no. So management changed. Regardless of whether you think that was for better or worse, that's what happened. Today, I think that a lot of natural resource disputes are less about fundamental questions of law, but more about, are we going to cut this tree or that tree? And is it going to be 75 feet from a stream or 100 feet from a stream and 19 inches in diameter or 21 inches in diameter? Those, I think, are questions of, they're social questions or economic questions or ecological questions. There are a whole bunch of things that in most cases now, collaboratives are working to figure out the answers to. But they're not the same legal questions that we were faced with 30 years ago. In some cases, they are. If HFRA says that you can't build more than a quarter mile of road outside of the WUI, then that's a question of law. But in a lot of cases, they're different questions than we faced in the past. So the simple question that I try to grapple with, and that's just my supposition. I'm not saying that that's Governor Bullock or anybody at WGA's position. But I think that the question in essence is the federal judiciary the best venue for settling the forest management disputes of the modern era, which I believe on many levels are different from the ones in the past? And if the question is yes, then are there some kinks or flaws in the current system that could be improved upon to produce better outcomes or a better process, not to prejudge the outcomes? And if the answer is no, then what is a better system? Or what are the flaws in the current system that need to be fixed so that we have a better system? Maybe we don't need a new system, it just needs to be improved upon. So what does that look like? And with that big, complex question, I'm going to open it up to the panel, starting with Jim Riley, to get his perspective on that thorny one. Jim?
Thank you, David. You know, this is an interesting question to begin this with. I want to return to something Troy said at the very beginning, that observed that both environmental interests as well as industry interests equally access the judicial system to try to advance their outcomes. I don't think that's accurate. I think that the judicial system has proven to be a very unbalanced and a process for resolving these questions, because it's much easier to litigate to stop things from happening than it is to litigate to compel things to happen. And if you look at the record, you'll find that there is far more litigation brought by people seeking to block actions than people who have an interest in seeing actions occur. But that is the fundamental question. And I would hope everybody on this, when they take a look and says, has litigation been a benefit to the whole process? I think an objective look would tell you no. Here today, we are relitigating the same issues under fundamental laws that we've litigated now for several decades. So most recently, we are once again litigating the question of when does consultation under the ESA have to occur? That just is not bringing clarity to what the requirements of law are, but to sort of rechurn the same questions over and over again. Furthermore, litigation is... Go ahead, David.
Jim, you're referencing the recent litigation commonly known as Cottonwood, correct?
Yes. And I would think if you look back, I don't have them all, but the Cottonwood decision is, that's a fundamental question about procedures under the Endangered Species Act that have been around since the act was passed, and have been a matter of several different pieces of litigation. But then furthermore, the litigation frustrates, in my view, collaboration, of which we've been a big part of. I help with that a lot. But just a little factoid here. The most recent data I have, of the 24 projects in the state of Montana that are under litigation today, 13 of those were the result of a collaborative process. And I can tell you, having worked with those collaboratives, it's very frustrating to find that you spend years working on a project, you get agreement, and then you find somebody who did not participate would then pursue litigation to block the outcome of the collaborative. You say, why collaborate? Furthermore, litigation has frustrated orderly and necessary forest management, either for forest health or for those businesses that depend upon it. I just observed this Cottonwood decision we just talked about now threatens 80 vegetation management projects in regions 1, 2, and 4, which have been years in the making and are scheduled to happen here, could all be interrupted in some fashion. And then lastly, I'd say it's consuming extraordinary resources, both from the government and from the various parties involved that are fighting over sort of these litigation disputes to try to compel an outcome, rather than focusing on the fundamental questions of what's required for land management and what's not, and monitoring and providing good information going forward. So for all of that, I would just say, David, and answer your question, it's, the courts are not a good place to resolve what are the fundamental questions here, and we have to seek alternative venues.
Okay, thank you, Jim. I'll leave aside for the moment the question of then what is, and turn to Susan Jane to get her view on it, both being a person as somebody who participates in a collaborative and as somebody who has been a litigator in the past over forest issues.
Sure, thanks, David. Well, I think Jim raises some interesting issues, and in a lot of ways, I would agree that some of the issues that we're fighting over today are fundamentally different than they have been historically. That said, I think a lot of many, if not most, if not all of the legal arguments that we're talking about, and Cottonwood is a great example of that, frankly have provisions of law that have been well settled for many decades. So there really isn't a new question of law there. It's a question of whether or not a particular project or process complies with those legal requirements. And enforcing those legal requirements in court is a fundamental part of our democracy. So I think that it's important to really consider what it is that people are fighting over. And that, I think, does implicate other procedures that perhaps are more satisfying, like collaboration. I've been involved with the Blue Mountains Forest Partners in Eastern Oregon for more than a decade now, and that work is very challenging. It's very difficult to sit around a table, or preferably out in the field, with people that disagree with you very vehemently about the future of a piece of ground or a community. But I think it takes that hard work of really wrestling with a difference of opinion to figure out how you can work together to come up with a solution that works for multiple stakeholders with multiple interests. And I think that when groups are able to come to agreement in that setting, those agreements are far more durable than what you may get in court. And so I would agree with Jim on that point that litigation is a great tool for stopping bad things from happening, but it is a poor tool to encourage good things to happen. And if you want to encourage good things to happen, you may in fact have to leave the courtroom and spend some time out in the field on the ground talking to stakeholders and learning their values and what they want from a piece of land and the land management that may be required to manage it. So I think that we really do need to focus on what problems we're trying to solve here with the conversation around whether litigation is a good tool or if there are better solutions to that. You know, what is that problem that we're trying to solve? Are we trying to reduce litigation? Are we trying to restore land? Are we trying to ensure the viability of rural communities? So I think really calling the question is important in framing this debate, because it is a very contentious one and very emotional one. And I'm not sure that emotion is the best way to resolve very sticky land management issues.
Thanks, Susan James. Laura, you sit in a hotbed of some of the litigation that most frustrates people, and that comes out of Montana, frankly, and a lot of Region 1. It's certainly not exclusive to Region 1, but from your position there, what are some of the problems that we're trying to solve, and what are some of the frustrations that you hear coming from people?
Were you asking me that question, David?
Laura.
Okay, that's what I thought.
Well, I apologize. I thought that was directed to Susan. Yes, from Trout Unlimited has not been on the litigation side, but as we talked about before, has been on the receiving end of having gone through some of the collaborative process and then have some of the particular projects challenged in court. And from our perspective, that litigation elevates process over substance. And while indeed there may have been missteps in either the environmental documentation or the particulars of the process, fundamentally the litigation is more process-oriented than the substance of forest planning or fire policy or conservation. I mean, I think as you, David, talked about in your introductory remarks, 20 years ago or even 30 years ago, that litigation or litigation over forest planning and particular sales was really hammering out big questions about what was the Forest Service duty to implement forest plans and to manage for multiple purposes. And many of those really big overarching questions of what the Forest Service duty is has been hammered out through that environmental litigation. So Trout Unlimited really believes that sort of sale-by-sale litigation is a strategy that looks in the rearview mirror as opposed to a strategy that really moves forward national forest management in a way that's helpful for both wildlife species and rural communities.
Thank you. I think that everyone has touched on this idea of collaboration so far. So I'd like to hear from Chris from an agency perspective about whether they should or whether it's possible for collaboratives to have some type of higher bar for the projects that they produce when it comes to litigation or challenges from people who weren't participating in that collaborative, or just anyone in general. Should collaboratives get some special treatment, or is that even possible from an agency perspective?
Well, I think what you're hitting at is one of those questions that we've talked a lot as this conversation has happened around the way decision making happens in federal land management agencies, and then, you know, what are the incentives for folks to participate both in collaboration and in some sort of alternative process to litigation, such as an alternative dispute resolution, and this is pretty challenging. And so as an agency, I think we're very open to any idea, and the Chief has spoken openly about this, any idea that fosters any mechanism that allows us to collaborate and engage with people more effectively than the current set of tools that we have right now. And so one of the challenges I think we often feel is that in our efforts sometimes there can be this disconnect between working collaboratively to design a project versus then preparing that project to work through the processes to be defended, let's say, in court on something that maybe is controversial. And that second part, the challenge I think for us at times is that the language we use, the analysis we use, the time that it takes often can feel like a disconnect from the very groups that we were collaborating with up front about the real issues we're managing towards. And so any process that we can use that helps us focus more on working closer with people, getting the project right, getting wider support for the actions we're going to do versus the more process-oriented, the more the pieces that we're more focused on in terms of what may occur during preparing for litigation, I think is very helpful to the agency. So your question on a tighter bar, I think this is pretty challenging for us, an agency, to think about that incentive, right, of how you get people to more participate in a collaborative and also maybe participate in some sort of alternative process. I would say we're open to any idea, but there are, yes, as you point out, there would be some statutory lines and others that we're not able to cross.
So there's,
sorry.
Go ahead.
For Ziemer with Trout Unlimited, could I add just a little bit more on that, or do you want to move on?
Absolutely. Absolutely.
Yes.
Go ahead.
And I really appreciate your words on that. From Trout Unlimited's perspective, we are fully committed to engaging in these collaborative processes, and our staff on the ground across the West are engaged in many collaboratives, whether it's with private landowners and ranchers on water and water efficiency, or in a national forest management or a range management context. And our experience coming out of that is part of what led Trout Unlimited to work with Senator Tester and others from both rural communities, the timber industry, and other conservation groups on the Forest Job and Recreation Act. And while that is new statutory authority, there's ways, even without that new statutory authority, to do what that act intends, which is to put that collaborative process up front in the planning effort at the development of a large picture forest harvest plan. And it takes a long time to hammer that out because, as Susan pointed out earlier, in that collaborative, what makes it difficult is because you come to the planning process with different points of view and different priorities. But the beauty of that long and difficult, frustrating, I'm not saying it's never easy or graceful work. It takes a lot of time and patience and dedication by the folks involved to get to the end. But in the end, you can come up with something that gives each entity a piece of what they need. Maybe not everything that they want, but what they need to buy in to the results of that collaborative multi-stakeholder planning process. For example, for Trout Unlimited, it's going to be important to stay out of roadless areas and DSA species critical habitat areas, you know, and to address road crossing and other watershed impairments. For the timber industry, it's going to be important to have a given amount of board feet that can be guaranteed on an annual basis in areas that they can actually access. Right? So there's trade-offs involved, but in the end, especially if we can turn some of those receipts back into restoration, we end up getting to a better place in terms of forest health than before the process. And for Trout Unlimited, that's really the key to, and the reason to spend the time and energy engaging in the collaborative process is if we believe at the end of the day, even with the timber harvest going forward, is forest health improving over time? And if the answer to that question is yes, then we've succeeded.
I think I've heard everyone say that there's great value in getting more people involved in the front end of the collaborative process and building a bigger tent. And that is almost, or could be more effective than trying to do something on the back end to limit litigation or access to the courts. And I've heard that from other people attending the workshops and such. But what do you do with litigants who simply want to say no and don't have interest in participating in that collaborative process? Is that just a fact of life that you have to deal with, or is there some way to address folks who don't want to participate in the process and don't want projects to move forward?
So, David, is that an open question to all of us?
That's an open question, because I'm not going to put anybody on the spot if they don't want to get into that one.
Well, this is Jim Riley again, and I speak to this. I think Laura raises a very important question in her initial point in her initial comments, that there is a big difference between a litigation over process and litigation over substance, and we see more and more today litigation over process. And I think the reason for that is, as the processes have evolved and been interpreted by the court, in my view, the process has become either loosely defined, ambiguous, or internally in conflict, so that the agencies, even with their best efforts, can't ever be assured they've complied with it. So that gives great leverage to people who don't want to see projects go forward. And I think we just have to accept that there's always going to be some organizations that just say any activity is bad, to always argue that the process wasn't met. And then here's the problem, is we found as we've engaged with Trout Unlimited and others ourselves in collaboration, and and somebody brings a process complaint against it, the courts have said, look, we admire the heck out of the fact that you guys did a lot of collaboration, but that does not, just by the fact that you collaborated, absolve the agencies of having to comply with a process they can't comply with. So the project's enjoined. So look at the Colt Summit project in Montana is a great example of that.
David, this is Susan Jane. Maybe I can jump in there. I think your question about, what do you do about litigants who don't want to collaborate and do come in after a project's been developed and litigate. My view as an attorney is that that's part of the process. That's our judicial system. And suggesting that certain individuals or interests should be either precluded or the bar raised for them to challenge what they believe in, and if a court decides an illegal project, I think that's a pretty dangerous road to go down. And I know that many people don't care for process, but as a self-described NEPA nerd, I like process, and we have many procedures in land management and our democratic system that are very important procedures. And so while I certainly appreciate the focus on substance, and as a collaborator in our projects that we develop on the Malheur National Forest, we focus a lot on substance, but we also spend a lot of time on procedure to make sure that we can actually implement the substance at the end of the day. Because if you don't have an adequate process or you don't have adequate substance, people are going to take notice. And does that mean that we, as either collaborators or as litigants, have an obligation to make sure that both the substance and the process are adhered to? Yes, we do have that obligation. So I think that, you know, I would hesitate, even as a collaborator, to say that collaboratives should get some sort of leg up or a thumb on the scales when it comes to litigation, because that really does, that changes the scales of the judicial process. And for any area of law, whether it's natural resources or product liability or civil litigation, I think we got to be really, really careful if we're suggesting that in this one area of law we should make changes to how parties enter the judicial process. And it's just not something I think we should take lightly.
I appreciate.
Oh, go ahead.
Go ahead with your comment, and then I'll follow up.
Oh, okay. This is Laura Ziemer again with Trout Unlimited. And Susan, I also agree with you that if we start talking about short-circuiting access to the courts or access to judicial review of public land management, we're on dangerous ground, because if we tinker with that, there may be unintended consequences of reducing or putting a straitjacket on judicial review of public land management. And I wholeheartedly agree in the idea that daylight and transparency is the best process or best antidote for government decision making. On the other hand, I believe in terms of trying to move that front-end collaborative process forward and through the judicial review system, at least initially, those groups who are part of that collaborative process on a challenged Forest Service position then have an obligation to show up in court and support the agency's decision-making and to support that outcome. And I think that over time, that will create its own body of law and precedent that will begin to, on its own, raise the bar for challenges to collaborative-based agency decision-making. So I see it as it's a long and difficult road to hoe, but I see that it does, in the end, it will begin to change that judicial review process and the nature of litigation over projects.
So I understand that, Laura, and I mean, that's based on the presumption, though, that there is a viable process here that the agency can conform with, and I'm not sure there is under the law right now. But I also agree that there's probably little real opportunity here to talk about restricting the kinds of people that can and can't go to court. Perhaps you can in the circumstances. But that's why I'm in favor of alternative dispute resolution. The one thing that's missing from this process, every one of these projects starts with a statement of purpose and need and some agreement upon the general objectives of what's trying to be accomplished. And when people use the courts and litigation to try to block a proposed project, they are never, under the existing processes, they are never compelled to come forward with their alternative for what would accomplish the same outcome and what they would want. So they, having never had to put that on the table, it's not the same as those who collaborate to try to find the right answer to accomplish the purpose.
So I think, this is Chris French, I think that both within the agency's development of policies and certainly as signaled by Congress, there is a value that is being asserted towards participation, engagement, collaboration early on in a process, and how that affects your ability post-decision for litigation. And so, you know, what I would say here is that, you know, we see the value of Congress putting into some of our authorities lately about, requiring collaboration in order to be able to do certain things, asking us and requiring us through 218 to put together a pre-decisional objection process that we see as an extension of that engagement and collaboration process, so that we can resolve issues prior to us getting to decision. And Congress was specific in signaling that you had to provide substantive comments and participate in those administrative remedies before you had the ability to sue, such as through HFRA. And so I think those pieces signaling from Congress, and I think then our agency in promulgation, the role of engagement early on in projects, such as through the 2012 planning rule in terms of land management planning, signal a shift and a change that we're trying to focus all parties involved in to reduce litigation, to reduce the conflict that leads to decisions that are not supported.
So I've heard from, I think, everyone in some form that maintaining the citizens' right to challenge the actions of their government is important, and a fundamental right that we should be extremely careful to tinker with or not at all. However, we do have legal and statutory limits on litigation, standing being a simple one that I believe Jim mentioned. How would you, in a concrete way, and I'll open this up for anyone that might have an idea, in a concrete way, how might you thread that needle between maintaining people's right to sue, but at the same time either narrowing the scope of the litigation to cover pertinent facts or issues, or at the same time further limiting standing so that if you didn't participate, then you can only bring, NEPA, ESA, something like that, and not be cutting this tree and that tree, outcomes versus process. How would you thread that needle between those two, I think, pretty basic ideas that it's not entirely open-ended because that's not the way our legal system works. At the same time, people do have a right to sue, and that should be maintained. Okay, well, maybe that wasn't a great question. Chris, from an agency perspective, you all have dealt with litigation in a bunch of different regions across the country. Are there little things that you think could help the agency with the question of process and how that gets litigated in courts?
So I think that the continued support by Congress in highlighting the importance, as I spoke to before, of engagement, public engagement, collaboration in our decision-making processes, and how creating standing or participation early on gives you the ability then, if you still disagree, to litigate. I think that can be very helpful. On your specific question about from an agency looking at the focus on process versus the substantive sort of differences or issues, I need to just say, I mean, we as an agency, and then I think about the work that I lead on behalf of the agency, first and foremost, our value is the role of citizens in our processes and their ability to help shape management on these national forests, and then check us through every process we have, whether it's in project development, objection processes, comment and then objection processes, or through litigation. I think that fundamental value is something that we also share as and a really important part of the system that we are a part of. I think if there was a way that there could be some weight given to, more weight given to that collaborative process up front that allowed the conversation to be more focused on the process maybe than some of the substantive issues. Maybe that could be helpful. I'm not sure. At the end of the day, I think what we look at is not maybe technical pieces that drive litigation one way or another. We look for either authorities, statutes, practices, collaborations, partnerships that bring more people to the table, that resolve issues earlier, and create networks around the work we're trying to do so that there's broader support for the work that we're doing. And that we have shown can reduce litigation.
This is Susan Jane. I think Chris is on to something there. And there are a number of programs that do incentivize collaboration, and probably the best example is the Collaborative Forest Landscape Restoration Program, which in my view has been highly successful. We have a number of projects in Region 6 in Oregon and Washington, including the collaborative group that I'm engaged in on the Malheur. And through that, which is, it's a little extra money, not actually money for collaboration and planning, but for implementation. But that little bit of extra money and the focus on really trying to do project development differently and to take a large landscape look at the restoration need and to address, everything from terrestrial and aquatic to recreational demands and those sorts of things. That sort of incentive, I think, is highly successful. And it's successful because it does bring people together. And again, Laura's right that it is very challenging work, but also highly rewarding when it is successful. And people want to be part of success. They want to be part of solving problems locally, of having their own local flair as part of how local lands are managed. And so if you want to incentivize working together and coming up with projects that are durable and, frankly, at the end of the day, the important thing is they get implemented. I think looking to programs like CFLRP and expanding that program, increasing the authorization and appropriation as opposed to having it, I think that is really where the future of land management lies. Now, I don't think that it is a silver bullet by any stretch of the imagination, and again, I don't think that you can force people to collaborate, and you can't force people who don't want to participate in that way to the collaborative table. So there has to be a way for them to continue to engage. These are public lands. And if they feel that laws have been violated, substantive or procedural, then to have their day in court. So I think looking towards, again, as Chris was talking about, the 2012 rule and other programs like CFLRP, the front-end work of public engagement and collaboration, I personally think is the future of land management.
And I'd like, if we can stay on this topic for just a bit longer, this is Laura Ziemer with Trout Unlimited. I want to take even a bigger lens for just a moment and talk about Trout Unlimited's experience with other federal agencies on very difficult natural resource planning processes where we have gone to Congress and authorized both a process and funding, importantly the funding piece to support that collaborative process because it does take time and it takes resources to do a good job of planning. For example, under the Bureau of Reclamation's authority, the Secure Water Act, there's now basin study process where you do exactly what Susan described at a basin level, whether it's as large as the Upper Colorado or smaller, such as the Upper Missouri watershed in Montana, and do the hard work of putting together that landscape scale review of what are the needs of the existing stakeholders, where are resources coming up short to meet those needs, and what kind of adaptive management strategy and what kind of strategies could you put in place to try to get to the point where all stakeholders' needs are met in that basin. And it's now a front-end prescribed process in statute that has funding to support the planning process, both funding for technical investigation and data collection and analysis, as well as facilitation and public outreach. And if we, if we say, wow, well, look, other federal agencies are doing that and engaging in that, how come we can't do that on a Forest Service basis?
Laura, I think that's an excellent question, and I want to come back around to that because I don't think it has an easy answer, but I think it's an excellent question. Bill, do you have anything to add here? Or has anybody, any participants chimed in?
Yes, we've gotten a couple of questions from participants, so I'll just lead off with the first. The question is, the major basis for litigation has been and continues to be NEPA. NEPA does not address substantive issues, but is a procedural weapon used to stop projects. Do panelists support litigation to allow EAs instead of EISs for collaboration projects?
So this is Susan Jane. I'll take a stab at that since the question comes from my good friend Scott Horngren. You know, I think it's an interesting question. I guess in my experience these days, there's honestly not a lot of difference between EAs and EISs in terms of their length. I've read a forest plan that was shorter, forest plan EIS that was shorter than a restoration EA for a collaborative project. And I have often communicated with my Forest Service partners that more words on the page does not make it a more solid NEPA analysis. So I think that there's functionally not a lot of difference between EAs and EISs these days. And really the question is, have you done an adequate analysis? And an adequate analysis does not necessarily have to mean a very long analysis. It just needs to be adequate. So I am pretty leery of legislation that draws a line between an EA or an EIS. I think you need to do the requisite analysis. And that does not need to take a lot of pages to do, but it needs to take sufficient pages to do.
Thank you, Susan Jane. Oh, go ahead.
I was just going to chime in here. It seems to me the threshold premise of Scott's question is, should there be a simpler and perhaps more defined process to implement a collaboratively supported project than one that does not have a collaborative behind it? I would say absolutely yes. If you want to encourage collaboration, if you want to get people at the table up front to decide what needs to happen and not leave it to the end, there ought to be a precise and defined and cleaner process to implement those. Whether that means EA versus EIS versus something else, I don't have an answer to that. I respect what Susan said, but it ought to be simpler.
Thank you, Jim. So let's get into the latter part of what the webinar title is about, and that is arbitration and other forms of alternative dispute resolution, which is what people have talked about for some time as an alternative or potential alternative to our current system of litigation. I think that there are certainly advantages and disadvantages with any type of alternative dispute resolution. But when these conversations take place, it quickly gets complicated with unintended consequences and questions about who's going to decide whether the arbitrator has to just review the administrative record or if there's going to be discovery, whether you allow whatever the arbitrator-like person is, not just to pick a project among competing proposals, but make a determination about compliance with various statutes, et cetera. So are there things both from an industry perspective, Jim, and an environmental litigant perspective, Susan Jane, just put you on the spot to begin with, that are that would be essential in either tweaking the current system or creating something new, some type of alternative dispute resolution that are not, you can't compromise on, that you would have to have discovery in any type of ADR, for example.
Well, you mentioned Susan first, didn't you?
I'll let Susan Jane take it first.
Sure, it's going to be really short. So I have no sympathy for an ADR approach as an alternative to litigation or other administrative review opportunities. I have yet to hear someone make a very compelling case for it. And as David mentioned, it gets extremely messy very, very quickly in terms of, you know, the mechanics of such a process for natural resources issues. So I really don't entertain it as a viable alternative. And I have yet to hear a comprehensive, persuasive articulation of why it would be better than the status quo. Understanding, of course, that many don't like the status quo, but as a lawyer, I like the status quo, and I know how it works. Everyone else knows how it works. I think an ADR approach to natural resources management would be probably more controversial and result in more gridlock than what we have today.
Many proponents of arbitration or ADR will say that they're not looking for any outcome that is biased or unfair, but that is faster and more certain, so that litigation does not take a year or 2 years, but that issues can be adjudicated in 6 months, and then win or lose, everyone can move on. That's one of the advantages that we hear from proponents.
Well, and I guess I would ask to see the data on that. I think litigation can also move very, very quickly, particularly if you're moving for a temporary restraining order or a preliminary injunction. Those procedures can take less than a month, and then you've got an answer. Certainly in some cases, if you don't like that answer, you can then appeal, and that appellate process may take longer. But in many, many cases, litigation, certainly it can be a drawn-out process. I don't deny that, but in my experience, it is not a long, drawn-out process. And at the end of the day, a judge decides who wins or loses. I have concerns about ADR because who is the arbitrator, and does that person understand science and law, which are the issues that come up in litigation around natural resources issues? Would it just be limited to land management issues? What about fisheries issues? What about range management issues? Are those going to be part of this as well? Would we be looking at other sorts of congressional designations or presidential designations? What if you don't like one of those? Do you have to go through ADR to resolve those disputes? I'm just not at all convinced that the ADR path is a faster one with more satisfying answers.
So, to chime in here on this, David, I want to talk about something Laura said again earlier, is because in our experience with collaborative projects, every time we've talked to Trout Unlimited or National Wildlife Federation or other interests, we find ourselves talking about landscape level or basin level, is what I heard Lauren or Laura or Susan describe, sort of decision making. You know, what about this whole landscape here? And what the part of the problem is that there's no planning mechanism to make decisions, fundamental decisions about the objectives for treating the landscape and having those disputes up front, either through litigation or ADR, as to whether you're going to treat or not treat there. And then it all defers until there's a project proposed and everybody brings forward their fundamental objections to the treatment plan in the terms of individual projects, often procedurally. And it seems to me that frustrates this whole process. So to answer your question, I think we have to look at reordering the decisions. So broad decisions get made for broad landscapes. They get resolved either through the judicial process or an alternative dispute resolution process then. And then the implementing actions, though, I think could go to an ADR process that quickly say, did they conform to the purpose and need, or didn't they, that was established for the landscape? And quite frankly, the ADR process we have in place right now is you seek resolution from Congress.
Well, and I think, Jim, you make a really good point there. And I think what you're arguing for are forest plans, frankly, that do take on some of these issues that we fight about in court. You know, how do you, what do you allocate that, 40,000 acres to? Is that timber management? Is it, a species habitat designation, protective designation? What about post-fire logging? I know that's a big one that I litigate on frequently. Let's have that debate up front, and let's put in standards and guidelines and some adaptive management in our forest plans so that we can fight about those issues up front, and then we can go about implementing those plans and implementing projects. I think that is exactly the right role for forest planning.
Right,
yeah,
which I think
go ahead, sorry. Oh, well, I was just going to jump in that I think that also goes to the question we had from Scott Horngren about NEPA tiering and the difference between EA and ESs. That, Susan, you're right. If we can engage in this landscape scale process, taking a page, say, out of Reclamation's basin study process, and hammer out some of those difficult and, really natural resource fraught decision making up front and get to a point where we can agree on that, and that was really the intent of that Forest Jobs and Recreation Act that Trout Unlimited and Jim and others worked hard on. Then maybe we can get to an overall NEPA document that the project can tier to. So it's going to, I think it's not only going to have that, address that substantive component where Trout Unlimited is frustrated that the litigation seems to be more process-oriented than substance-oriented, and we can then actually align our process with our substantive conservation planning if we have that kind of big overarching NEPA document ultimately adopted that the individual projects can tier to. So I see it as solving not only some of the substance problems, but also addressing some of the procedural questions at the same time by making the NEPA process align with the decision-making process.
So, and I agree with all of this that's been said, but I'm curious to hear from Chris, because in the first round of forest plans, I believe the Forest Service really tried to do tiered decision making, and there's been some work done. I'm not fresh on it, but with the forest plan, we thought decisions were made in forest plans about fundamental management of basins and other things that were relitigated over and over again then in the context of the implementing projects. And so I'm not sure why it's been so difficult to bring this about. Maybe that's where we need to explore some more.
Well, I think the fundamental issue here is, again, what's the incentive? And the conversation we have is how many bites at the apple do you get? It intrigues me to think about the ability to promulgate a large landscape type decision such as a forest plan, and that every subsequent project that is implemented under that plan may be, instead of the ability to litigate on that project, that maybe there's an ADR process that's associated with that. That feels like an incentive that could be helpful for many of the issues that we talked about earlier. I think the challenge is that a lot of folks that would be a tough one. I think that people want to be able to litigate at both levels, and that's been our challenge with the previous thinking of the role of how a forest plan could be, which has been debated in courts now many times. So I think if you are looking for an alternative, it would have to be or could be, I should say, in a light like what we just talked about or something similar to really provide the sort of effects that I've heard many folks talk about.
So for Laura and Susan Jane, what, if anything, does the agency and collaborators and others get for that big picture up front that everybody, I hear, agreeing on? Is it some type of alternative system, or is it a narrowing of standing, or is there some room for something at that project level if we do the things beforehand that we're all agreeing on?
This is Susan Jane. I am not comfortable going there, frankly. I think that the two-tiered approach, giving the public the opportunity to challenge a forest plan as well as site-specific projects in court is certainly something that my clients feel very strongly in favor of. And without understanding more about what sort of changes might be suggested for challenging a site-specific project, I'm not comfortable really suggesting that it has merit, because I don't know what the contours of that is. And as I indicated earlier, the ADR approach, which, by the way, is shorthand for a number of alternative dispute resolution processes, not just one, there are 3 or 4. Without knowing more about that, it's not something that I'm willing to sign off on.
Thank you, Susan Jane. Laura, if you can chime in here if you want. If not, we'll go to Bill and see if there's more questions.
Sure. I think I have to agree with Susan on this one, that it's really a difficult question to answer in the abstract, because what we're talking about is so place-based and so site-specific in terms of the outcome and also the contours of what that upfront planning actually does. So I'll take a pass on that for now.
Thank you. Bill, do you have anything to add here?
Sure. The next question speaks to that a little bit. It's about a type of arbitration within ADR. And the question is, what about baseball arbitration as an alternative conflict resolution mechanism? It requires objectors to formulate their alternatives that address purpose and need. Then the arbitrator picks the alternative. Over time, this will make people more reasonable. Any thoughts about that from the panelists?
I think the argument here about it oh, go ahead.
No, go ahead. I'll chime in later.
Okay, I think the argument here about it making people more reasonable is that if in baseball, literally, the two sides bring how much they want to pay the player or get paid to the table, and the arbitrator picks one. So they each try to get as close to the center line as possible so that the arbitrator sees them as being more reasonable and picks their proposal. So in that sense, I think the person who's asking the question is assuming that if everybody has to bring their proposal to the table, they're going to try to make the arbitrator pick theirs as the best, most reasonable one.
Yes, this is Laura Ziemer with Trout Unlimited. I agree with that. And I think it does tail nicely with what I was going to start in on, which is with talking about alternate dispute resolution without having, as we've been having such an interesting and productive discussion around so far, without having that upfront multi-stakeholder process where we hammer out these larger concerns about how the landscape is being managed. If you don't have that up front, then as Susan, I think, very eloquently said, then the different points of view bring those larger landscape concerns to the table at every project, because those larger concerns haven't already been aired. And that's where talking about alternative dispute resolution without first addressing the larger landscape is really fraught with perils, in my view.
So this is Jim Riley. You know, I really like the concept of baseball arbitration, because to me, it parallels the philosophy of what the collaboratives are about. And when we get together in a collaborative, we look at a landscape area, we agree on some general objectives, and then everybody around the table brings their proposal about what they think would be the management plan to accomplish those objectives. That's how we develop numerous, including the FJRA proposals, numerous proposals in various states to do things. Litigation is all about articulating the reasons why you don't like something, but the litigants never have to put on the table what they want to see happen. So that's, you see, that's entirely philosophically different, because you're just always arguing in the negative about what you don't like and never have to. That's where we wind up with the frustration over this process. So whether that's an alternative dispute resolution issue or not, but the concept of making people put on the table what their alternative is, and then the choice being selecting between the ones that accomplish the objectives in the best manner really resonates with me.
What if they simply want the no action alternative?
Well, then here, David, I would say that ought to be at the very beginning of the process. And we just recognize there are people that believe that no matter what science or substance or other things out there, that the no action alternative is always the best answer. Let's have that debate at the very beginning. And if they prevail, then the process stops. We don't go forward with a collaborative process to develop actions. It stops then. If the other side prevails, the process moves forward, but they're not allowed to keep bringing up no action over and over again. You know, under the guise of procedural process inadequacies.
So collaborative projects should not have a no action alternative, because then what's the point of doing the collaborative project?
Right, or up front you make some broad purpose and need decisions and you sketch out what the management proposals would be, and then you litigate it. Right, if people are prone to litigate it at the landscape level, but then once they're done, they don't get to relitigate over and over again just to try to block the process.
Chris, I don't want you to make new policy for the agency today, but from an agency perspective, are there incentives for collaboration such as that you're willing to explore? I think that you've already answered that yes, but I just wanted to come back around to it.
Well, yeah, I think this is where Congress has clearly spoken. If you look at the Healthy Forest Restoration Act or some of the authorities that have come under the 2014 Farm Bill, they have basically said that one of the outcomes of valuing upfront early collaborative process is that on the other side of that, when you're disclosing effects and considering projects through the NEPA process, that you can limit the number of alternatives you look at based on that collaboration. So I think that is Congress has spoken to that, and that's proven to be an effective way to create dialogue and an effective way for the agency to move projects, I think, through a broader understanding with folks that are involved.
Thank you. Bill, I'm going to go back to you if you've got something for us.
Yeah, we've got a question about similar vein about landscape level decision. So the landscape decision such that all projects under the easier NEPA and less conflict was done in Region 8. In Alabama, the forest did an EIS for a forest-wide restoration program that led to a 95+% drop in litigation. Why hasn't that been tried elsewhere? Any thoughts on that?
Chris, maybe we should begin with you on that one.
So, to be honest with you, I don't know enough about that particular project to speak about it well. What I would say is this, we often talk about ways that you can tier broader level decisions and then stack other types of decisions underneath that. I think the challenges we have as an agency in doing that is, one is sometimes capacity. The second is aligning the way that you align your actions that, most people will assume, will talk about as streamlined, which is essentially EAs or CEs that don't have significance associated with them, tiering them to some larger decision that is clearly about defining significance. And there can be a bit of a difference there. I think that can be challenging in places where you have highly complex environments and highly complex interlay of laws. And what I'm specifically talking about here is ESA and others. So yes, we see where it can be very effective. I can't speak directly to the Alabama example, but it does come with some challenges.
If no one else wants to jump in on that, I'm going to move on to a little bit different topic, and that's within the administration. What are the few steps that they might be able to take to either become more successful faced with litigation or to avoid litigation as it stands? And I just thought of that as the Alabama case was mentioned. Some folks have talked about some kind of NEPA review panel where before records of decision get signed and the NEPA documents are closed, they undergo a review with a group of attorneys so that the deficiencies in the document where the agency might be vulnerable to litigation can be identified and addressed and fixed so that they're more likely to prevail once it does go to court. Susan Jane, you have immense expertise in this. Chris as well, being from the agency. Are there things that the agency itself could do to limit litigation or become more successful once it occurs?
So this is Susan Jane. My understanding, Chris, correct me if I'm wrong, but my understanding is that the Forest Service has quite the robust review process prior to greenlighting, particularly EISs, but larger, more contentious projects. And my understanding is that oftentimes the Office of General Counsel for the Forest Service is involved in those reviews. So I think that there already is a fairly robust process. If I was going to be snarky about it, I would say maybe our lawyers are better than the Forest Service's lawyers, and that's why those documents still don't survive judicial review. I think the truth is somewhere probably in the middle there, but I think the Forest Service does a fairly good job of that, honestly. They're just not always right, and that happens.
Well, I mean, on that specific, this is Chris, we do have a fairly robust internal vetting process and public vetting process. So not only are there multiple layers of review and accountability into what projects move forward, but there's, of course, there's the objection process that happens before a decision, which we really see as a place that helps identify areas that we got wrong, we missed, we need to change, maybe areas of potential litigation that would cause us to pause and rethink some things. So we think actively in those terms, because at the end of the day, we want to be able to implement a project, and we want to be able to implement the right project, that adheres to all the laws that govern the agency, that meet the objectives of that forest plan, and are supported by the public that we engage to create that project. So that's the core thing. So we want to make sure that the pieces of things that we're putting in place is that we're going to have a project that will likely win. And frankly, we do pretty well. I mean, if you look at the amount of litigation we have across this agency, we don't get litigated on all of our cases. We get litigated on certain types and in certain areas, but it's a smaller percentage than I think most people recognize. And then the second thing I would say is that on the majority of things that actually do go to court, we've got a pretty good record of winning those. I think more than 60% of our cases that actually reach the court systems we prevail on. So, you know, we work hard to make sure that we are doing the right things and that we have the accountability in our systems to make sure that we can show that.
So, Chris, can I ask you this, Jim Riley? So, with all that rigor that you do and all the professional talent you have on it, why then do you wind up with things like the issue of the day is the Cottonwood decision that have brought forward a potential injunction against a sweeping set of your projects under a law that's been in place for almost 4 decades, and the fundamental question of what you have to do to consult under the Endangered Species Act? Why don't we know the answer to that now, and why are you vulnerable on those things?
This could engage a much longer conversation on Cottonwood, but I would say that, you know, in that particular case, there was an interpretation of the court on regulation that was not the same as had been the regular, the standing interpretation that both the regulating agencies and ourselves have been operating under. So I'm going to differ a little bit with Susan Jane's characterization in terms of this. I do think that in Cottonwood there was a specific interpretation of the Fish and Wildlife Service's regulations that had not been necessarily the status quo of how we've been interpreting things in the past, and so that changed things for us. And you know, and I think that was clearly articulated out in the response by the Department of Justice in our arguments on this, and so that's why it's having such a different effect. I think that we were operating under an understanding of a set of rules in one way, that through this interpretation those rules have been shifted, not based on necessarily on current past decisions, although there was Ninth Circuit had landed on a similar decision earlier. This one, they took a different avenue to get there through a different way of interpreting the implementing regulations of those agencies. So, and that could probably would be hotly debated by a number of folks, but that's our position and why Jim has had the effect that it did.
So I understand that and agree with it, but my point is, this is a fundamental process under the environmental laws that is reinterpreted now after nearly 40 years of the law being in place and of various court interpretations of that provisions that now has changed the whole process yet again. And that's what causes the litigation to be so favorable to people who just want to stop things, because you push hard enough. I mean, there's enough ambiguity in the laws themselves and in the implementing regulations. There's enough variable circumstances on the ground. A case can always get made that the agencies have not conformed with some fundamental process, so they quickly get an injunction, as Susan Jane points out, which stops everything, and then get sent back to the drawing board, usually for years before something comes forward. That's what's not working, and you know, if you want collaboration to succeed, that's what's got to be changed. Sorry, I got making a point there.
That's okay. I was just giving Chris or anyone else a chance to respond if they wanted to, but if not, we will move on. So in the short bit of time that we have left, I do want to get to a few more participant questions, but I wanted to bring it back to arbitration and ADR, as Susan Jane pointed out. That can mean a variety of things. And I was reminded of this given something that Susan Jane had said earlier about what types of projects or categories would be eligible, or could you apply some type of ADR to? So I'll leave it open-ended for anyone who wants to answer, but I think that it could give some people more comfort if the scope of what was eligible was quite narrow. So maybe I'll start with you, Jim, because as was mentioned earlier, the industry and environmentalists do have a history of litigating. And so, Jim, what types of projects or category of projects would you say should be eligible for arbitration or some other form of ADR? Because I don't think you would argue that it's ESA decisions as much as it is perhaps a narrow category of collaborative projects that, you know, have certain outcomes that, you know, more or less everybody agree upon.
You know, I think you already know from my previous comments that my preferred planning decision model here would be the one where there are upfront decisions made about landscape level treatment programs where people can afford themselves of litigation if they want to at that level. But once it's done, ADR would then be used to evaluate individual projects only, to just decide if they conform to the landscape level decisions or not. That would be the only remaining decision that would be available for ADR consideration. And whether that's done through a baseball arbitration process or through a special master or something, that would cause people to, I think, come together a lot more quickly.
But would that just include silvicultural decisions or land protection, wilderness, OHV? Is that completely open-ended? Everything under that plan would go to ADR, or would it be some subset?
Well, you know, I don't know if I thought that through enough. I mean, it seems like, I mean, there's this distinction that's been made and agreed to mostly in this call, I believe, about a distinction between process decisions and substance decisions. You know, did you maintain whatever a substantive threshold is, or did you not conform to the process? Those, I believe, can be handled differently. On the substance side, I believe that lends itself to ADR because it causes people to come forward and offer their alternative that they think makes the substance. On the process side, you know, when and how you narrow the process challenges so people can't use that as a guise for a substantive debate is what really is at the crux of this matter. And again, I think you got to do that up front, and then as the project gets implemented, you don't get to re-raise the issues.
Laura, Trout Unlimited is involved in Clean Water Act and a number of other statutes. What do you think about the scope of what could be eligible for some type of narrowing, whether it's ADR or, as you described, some forest jobs and recreation type of focusing of the agency through some type of congressional action?
Well, I think that's a really good question because I think it gets at the heart of this tension between changing judicial review process and the substantive planning, upfront planning requirements. And Trout Unlimited's view is that in order to walk that tension or to resolve that tension, we actually do need some kind of new authority, whether it's the Forest Jobs and Recreation Act or something like that, to set up that upfront collaborative process and give that more teeth, more binding a more binding and stronger decision-making presence within the forest planning context. And so that's where Trout Unlimited comes out in trying to address this back-end question of litigation over national forest management, is that there needs to be some front-end changes to incorporating as legitimate decision-making process on the front end of the landscape scale planning process, and that will in turn then change the back end of litigation over the decision-making.
Thank you, Laura. It looks like we have about 6 minutes left, and I want to leave that to Bill and questions from participants if we have them. So I'm going to turn it over to Bill, and then we'll wrap up here in a few minutes.
Yeah, thanks. We've got a handful of questions from the audience. The first being, how do you incentivize people to invest in collaboration without a certainty for a return on investment? Any thoughts?
This is Susan Jane. I appreciate that question, Lindsay. And I don't know as though there's a real easy answer to that. You know, I think any time anyone engages or embarks on something that involves people and involves natural resources issues, which are, as we all know, very contentious, there are no guarantees. And I would be I would be cautious about offers of a guarantee. You know, this is a risky enterprise to sit down with people who think differently than you or view the world differently than you do when it comes to land management, and to try to hammer out an agreement. You never know if that's going to succeed or fail. And so I would be skeptical of anyone that would promise, you know, for sure, if you sit around the table, we're going to come to agreement. I'm just not sure that that's fair, because we're talking about people and land management, which are two things that are pretty volatile. But that said, for those who do risk and are brave and bold, they're often rewarded. And I look at the collaborative work we've been doing in Eastern Oregon on the Malheur. All of that work has been extremely challenging. A lot of blood, sweat, and tears has gone into that work. And the agreements that we have are still very delicate and very tenuous. But we've also reaped the successes of that risk. So I guess I would suggest that leading by example, understanding that you may fail, but you know, life is not certain, and I think you risk because you believe that it's worth it. So that's sort of how I would approach that question.
Bill, I think we've got time for one more, and then we will turn it over to Troy and Bill for some final thoughts.
Okay, great. Final question is, assuming litigation can occur at both the planning and project level, can't you agree that there would be some non-litigation streamlining approaches to facilitate project analysis and implementation, given all the work that went into the plans? Any thoughts from the panelists on that?
I guess I would ask Scott to articulate what he might be thinking about as some of those streamlining options. Again, I think if you focus up front on the areas of agreement, it does expedite the planning and implementation on the back end. And over time, I think those agreements can evolve and become more complex to the point where the land management that's actually hitting the ground is more robust and touches more acres and therefore has more ecological and socioeconomic benefits. I'm just not sure we can start there, but I think we can probably get there after the requisite trust building.
Okay, well, I'm sure that Chris might have something to say on this from an agency perspective, but we are just running out of time. So I want to thank all of our panelists for being with us today. I think it was a robust discussion, a lively one. I think that we learned a lot. There's a good chunk of stuff here to take back to the Western governors and Governor Bullock and talk about how we might move forward. So I think that with that, I will let Troy take it from here. And I just want to thank everyone for participating and being on our panel. Thank you very much.
Thank you, David.
Thank you.
And
thanks, everyone.
Thanks, David, and Jim, Laura, Susan Jane, and Chris for joining us today. This is a difficult topic, a difficult set of issues. A lot of people have tried to crack this nut, and I don't think anybody's really succeeded. But I think you guys have this morning been able to lay out a really good foundation for us to work off of, and really appreciate you taking the time to do this. If you want to relive the past hour and a half, you can do so. If you go to the Western Governor's website, westgov.org, you can find a link to the webinar that we've done this morning. And as David pointed out, we have a lot of good meat here in this discussion. And so if you've got friends and family that would love to hear what we just talked about, just lead them right to that site. I don't think, am I missing anything, Bill, in terms of what? Excellent. Thanks again to our panelists. I would like to thank everybody who tuned into this webinar. We really appreciate your time as well. And this isn't the last one we'll do, so keep in touch with the WGA website, and we'll clue you into the next time we gather here. Thanks for your time. Really appreciate it.
Thanks, everyone.
Thank you. Excellent discussion.